Hello everyone, you're all very welcome to this, the latest in our series of webinars focused on the impacts that the current COVID-19 crisis is having on the built environment. For those of you who have attended our earlier webinars, you'll have seen and heard that we focused on the impacts being felt on the residential landlord and tenant sector, the commercial sector, looking at retail leases, hotel licensed premises, restaurants, and we also had a session dealing with the impacts on the planning and construction sectors. Today I'm joined by my colleagues Karol, who's a partner in our financial services department, and Paul Bassett, who is a senior associate in our construction department, and they're going to look at some of the impacts on the property development finance. Karol's going to speak first for about 10 or 12 minutes, followed by Paul, and hopefully at the end we'll have time for 10 or 15 minutes of Q&A. As always, we are trying to keep these interactive, so if you do have questions for any of the panelists, please do put them into the Q&A panel in front of you, and we'll try to get to as many of those as we can. I know last week we didn't get to about 20 or 30 of the questions, notwithstanding we ran over time, but if you do leave your name, we will pick up with you afterwards to the extent that we can, and you can also always just pick up the phone to either Karol or Paul directly. So I'll hand you over to our first speaker now, Karol. Thank you.
Thanks, Jamie, and good afternoon, everyone. So today we thought it would be useful to run through a number of clauses in LMA format facility agreements that should become more and more relevant as the health crisis evolves further and as we, I suppose, hopefully move to a measured reopening of the economy. So the clauses I intend to cover are financial covenants, in particular loan to value and projected interest cover, and the possible impacts of COVID-19 on those. Also mean to cover repeating representations, and in particular representations maybe that may pose difficulties for borrowers in the coming months, and finally material adverse effect and its use throughout facility agreements. As an overall comment, and I think it's important to say that in our view, lenders are taking a very pragmatic and collaborative and reasonable approach to their existing facilities. So, excuse me, the best advice we can offer borrowers at the moment is to stay in regular contact with your lenders and keep those lines of communication open. So to begin with, probably the most fundamental of financial covenants, which is loan to value, and it's probably one that is quite difficult to accurately calculate at the moment. So loan to value is typically defined as the loans expressed as a percentage of the market value of the property, determined in accordance with the most recent valuation. So the date of the valuation being used at the moment is hugely significant here. As we understand it, the general mood music in the property market is that property values on average have fallen by approximately 10% or so since the beginning of 2020. When looking at loan to value, the definition of loan is important because it includes loans made or to be made, or the principal amount outstanding of the loan. So any unutilized commitments will go towards the calculation. In addition, any amounts standing to the credit of a disposals account that could be used in prepayment of the loan will also go towards the calculation. But I suppose what's underpinning all of that are valuations. So lenders and borrowers alike should really familiarize themselves with the valuation clause in their facility agreements. And an LMA document, that's usually clause 15.3 or 16.3, excuse me. The valuation clause will detail when a lender, excuse me, or an agent may call for a valuation and who foots the bill of that valuation. So typically the clause will state that an agent or lender may call for a valuation at any time, and the cost of the initial valuation, a valuation carried out on an annual basis, and a valuation demonstrating a default has occurred or is reasonably likely to occur, will be for the account of the borrower. But I suppose in our view, lenders are taking a very pragmatic approach to valuations at the moment, given the level of subjectivity involved. I suppose moving on to the investment phase of facilities and interest cover, which tends to be calculated on a 12-month look forward or 12-month look back basis, so on a projected or historic basis. Other things being equal, we'll assume that historic interest cover isn't a huge issue at the moment, and we'll focus on projected interest cover. So projected interest cover is usually defined as passing rental as a percentage of finance costs. Passing rental is comprised of net rental income that will be received under leases during the calculation period. Of particular note over the coming months will be the deductions that need to be made from net rental income to get your passing rental figure. And you'll need to check your projected interest cover for this. For example, and probably of particular relevance at the moment, are rent arrears. You need to check your definition to see how long rent must be in arrears before it is deducted from net rental income to get your passing rental figure. The length of time is usually negotiated on a transaction basis, and really typically ranges from anywhere from 30 days in arrears to a full financial quarter. Other deductions maybe to be aware of in light of COVID-19 include costs and expenses incurred in complying with applicable laws and regulations with respect to the property, and also costs and expenses in respect to the provision of services of management, repair and maintenance of the property. Those costs are only deductible to the extent that they're not funded by the tenant. So if there are any costs associated with COVID-19 specific measures, you may need to consider whether they need to be deducted from net rental income also. I would just like to briefly touch on maybe cures as well. As many borrowers will have negotiated cure rights into their facility agreements. Typically, your cure rights will involve a borrower depositing funds into a locked cure account to a sufficient amount to correct a financial covenant breach, or indeed prepay a portion of the loan to, again, sufficiently to correct the financial covenant breach. You can typically use a cure right 2 to 3 times during the term of the loan, and there's a hugely limited amount of times in consecutive interest periods. What borrowers and actually possibly shareholders or subordinate creditors need to keep in mind here, any monies deposited in that account will remain there until, well, usually 2 consecutive interest periods have elapsed where the financial covenant in question has been corrected, not taking into account the amount in the cure account. So in this environment, that could be a significant amount of time. Just moving on to representations, and in particular representations that need to be repeated during the term of a loan. So what representations are repeated will have been a matter of negotiation at the time of entering into the facility agreement. In most facilities, representations are deemed, or repeating reps are deemed to be made by reference to the facts existing at the time, and the representations are repeated generally on a utilization, the date of a utilization request, a utilization date, and the first day of an interest period. So it's important maybe for lenders and borrowers to look at their repeating reps definition to see what representations are caught in that. So if there are a number of drawdowns anticipated during the term of a loan, so for example, in a revolving credit facility where a loan can be drawn and redrawn, repaid and redrawn, the further condition precedence clause is also important because an inaccurate misrepresentation may act as a draw stop there. There are a couple of repeating reps that are pretty much standard across all LMA documents, and I just want to touch on them in light of COVID-19. The first is the financial statements and representation, and particularly subparagraph D of that, which states that since the date of the most recent financial statements delivered, there has been no material adverse change in the business assets or financial condition of the borrower. And secondly, there's also a no default rep that is usually repeated, and that's qualified by material adverse effect, which I'll come back to in a few minutes. I suppose a mechanical point with the interaction between repeating reps and account operation. Typically in development finance and investment property facilities, the borrower is usually required to maintain a number of accounts, usually your sales proceeds account or your rent account, your deposit account, your disposals account, perhaps a VAT account, and a general account. All of the accounts tend to be locked other than the general account, which tends to be freely accessible by the borrower, and the borrower will have signing rights in respect to that. I would look at your general account provisions to see, I suppose, when the security agent or the lender may operate the general account. Typically, if there's a default or a representation is not accurate, the borrower's rights to operate the account and withdraw monies are suspended, and the security agent or the lender will have the ability to operate the account from then on. And finally, just moving on to, I suppose, a concept that is, I suppose, always of relevance in uncertain economic times, and that's material adverse effect or material adverse change. So material adverse effect is a catch-all concept that is designed to capture unpredictable or unforeseen events that would be, I suppose, particularly difficult to specifically cater for in facility agreements. It's important because it is used throughout finance documents, particularly facility agreements, to qualify events of default, representations and covenants, and will be present in 90%, if not all, facility agreements as a policy requirement of a lender or an arranger for syndication purposes. I suppose $1 million question at the moment is whether COVID-19 amounts to a MAC. And there is no easy answer to that, and that's simply because the clauses tend to be negotiated on a transaction basis. Maybe more intensively in acquisition and leverage finance, but the precise phrasing of material adverse effect and the, I suppose, circumstances and environment in which the borrower operates all go towards determining whether the clause has been breached. Again, just to note, we suspect that lenders will take a very pragmatic approach to material adverse effect, but given the extent of its use throughout facility agreements, I would familiarize myself with it. Now, just on your slide there, you'll see a typical definition of material adverse effect. A couple of high-level points maybe to note. Firstly, how subjective is the definition? Lenders will want the trigger to be as subjective as possible rather than objective. So it's the lender who's determining whether material adverse effect has occurred, and that's achieved, I suppose, in this definition in the first line, you'll see the inclusion of "in the opinion of the lender." Another high-level point I'd look at is just see what entities are actually caught by the material adverse effect definition. Is it just the borrower, or is there a wider obligor group that's caught by the definition? I suppose just to be aware that very subtle differences in phrasing can have a large impact on, I suppose, the scope of material adverse effect. So I hope you found the last few minutes useful. I suppose the key takeaways I would suggest would be, from a borrower's perspective, to stay in regular contact with your lender, review your financial covenants to see what needs to be included in their calculation. Look at the representations and see what representations need to be repeated and when, and familiarize yourself with the use of material adverse effect. So again, I'm happy to take any questions at the end of the session. And on that note, I'll pass you on to Paul Bassett, who's going to run through some construction considerations in LMA facility agreements. Thanks very much.
Thank you, Karol, and good afternoon, everyone. One challenge that COVID-19 brings to development finance from a construction perspective is the increased uncertainty that it brings to a number of key aspects of the project. These include the overall cost for the completion of the development, the impact it has on the timeline for completion, which is obviously connected to the date on which you can reasonably expect the development to begin to generate revenue. That can be either sales proceeds, rental income, or other forms of revenue. It also gives rise to an increased possibility for disputes under construction contracts. In terms of what I'm going to discuss today, I'll briefly touch upon the current site closures, the essential services for the purposes of the regulations, and just a very brief general overview of the current state of the legislation. I'll then discuss some of the cost and program certainty provisions that you would expect to find in any LMA development finance loan agreement, and also how these provisions will be backed off in construction contracts by developers. And then finally, I'll touch on some key takeaway points which will hopefully assist in stimulating some good Q&A once we're finished. So to firstly address the current legislative framework, I don't intend to go into this in any real detail because I'm sure most of you are at least broadly familiar with the current position. On the 27th of March, the government issued a number of guidelines with a view to minimising or slowing the spread of COVID-19. In respect of construction and development, those guidelines included the effective closure of most construction sites in the state on the Monday following those announcements. The only construction sites that were permitted to continue were those that were carrying out an essential service. Statutory Instrument 121, which came into effect on the 8th of April, provided for the legislative enactment of the government's guidelines. As I said, it entered into effect on the 8th of April. It was originally anticipated to expire on the 12th of April. It has subsequently been extended, and the current expiry date is the 5th of May, but as you all know, that may well be the subject of further extension. In terms of what counts as an essential service for construction and development, that's the definition is on the slide in front of you, which is taken from the regulations. And I suppose there's 2 points worth noting as you look through it. The first is, it appears that very little consideration has been given to the construction method or any site-specific considerations. There's no distinction drawn between, say, for example, open air civil works, which may perhaps be at the lower end of the risk profile, as opposed to an office fit out where there'd be a larger number of people working in a compact area. Secondly, as you look through it, you'll probably note that very few of the projects that you may be working on at the moment will come within this definition. Essential services really does provide for works that are related to limiting or minimizing the impact of COVID-19 or critical public infrastructure, such as road, rail, or utilities. The one development, form of development that does seem to be continuing at the moment, though, is social housing. The Department of Housing has established a process by which local authorities can submit applications on behalf of individual social housing developments and seek permission for those to continue. There's no legislation setting out the considerations on which a decision is made for social housing, but it does seem, anecdotally from speaking to people involved, that the project does need to have some relation to COVID-19 and also needs to be capable of completion within a relatively short period of time. But I suppose the overall position is, particularly in respect of private sector development, that construction sites remain closed and have been effectively since the government's guidelines were issued on the 27th of March. So moving forward into more specific development finance related matters. A key point of any development from the outset is anticipating lender requirements, and experienced developers will be acutely aware of funder concerns when diligencing any project. And I suppose chiefly amongst those considerations will be providing relative cost and program certainty to a funder. I say relative certainty because obviously cost overruns and program delays are unfortunately an inherent risk in almost all construction projects. However, a bank will expect a developer to have taken all reasonable steps to mitigate the impact and potential liability for cost overruns and project delays under the construction contracts. And any of you who are familiar with bank issued heads of terms documents for development finance will be used to seeing express completion dates set out at heads of term stage, as well as a requirement that all main contracts be on a fixed price lump sum basis. These are kind of high level commercial terms that get agreed at heads of term stage. In terms though of legal obligations on a developer under a loan facility agreement, these are typically set out in the development undertaking section of the facility agreement. And on the next slide, we've just copied what is, in our experience, very typical wording to find in any LMA development finance loan agreement. The first point there is the borrower must ensure that works on site are substantially commenced by X date. The second point is the borrower must ensure that the development is diligently carried out and is practically completed no later than Y date. Obviously, the first point there assumes a position where the facility agreement has been entered into before works commence on site, and that isn't always the case. But the key point to take from these two template clauses is that facility agreements will typically provide for an absolute calendar date on which works are required to be completed. It's unusual that a developer is going to be able to achieve a similar level of certainty in the underlying construction contracts. So there is a gap essentially between obligations to a funder under a loan agreement and entitlements under a construction contract. Now that isn't caused by COVID-19 and it isn't necessarily new, but the risk is exacerbated by the current delays and the uncertainty caused by COVID-19 restrictions. Cost certainty obviously is of paramount importance as well for any bank funded development. A facilities agreement will also typically contain a prohibition on a borrower incurring cost overruns, save in respect where those cost overruns are funded through one, savings to the project elsewhere, or two, an alternative form of financing, whether that's equity or subordinated debt, in a manner that's acceptable to the lender. The key considerations here, though, are that typically this funding will be required to be put in place relatively quickly. The clause on the slide in front of you provides for 10 days, but that obviously depends from transaction to transaction. But it still will provide a short period of time in which to address the cost overrun. And this can be an even greater challenge for projects that are operating on a relatively tight cash flow model. So when developers are considering their obligations to the funder, it will always need to be taken into account that a high level of certainty will be required, both in respect of project timelines, principally the date for completion of works, and secondly, cost overruns. And both of these have been affected by COVID-19 and the restrictions in place. If we move on then to the underlying construction contracts, where the developer will typically seek to pass off these obligations. The RIAI form of building contract is the most commonly used building contract for bank-funded developments in Ireland. That said, it's almost never entered into in its unamended form. The RIAI is typically subject to quite extensive amendment. So any comments that I make here need to be taken in the context of the fact that you're likely to have both general conditions of contract and a rather large bespoke schedule of amendments, which will set out the rights and obligations of each party. However, for the purposes of this talk, we have taken the standard RIAI terms, and I've set out 3 clauses below that I think are of particular relevance to COVID-19 and development finance perspective. Clause 2, which is the scope of the contract, effectively sets out the works to be completed by a contractor and the manner in which the contract is to be performed. Clause 2, however, also contains the powers of the architect, who is the administrator under an RIAI form of contract. Clause 2 contains very wide powers for the architect to issue instructions to a contractor, and those instructions can relate to the scope and nature of the work, or to a much wider range of issues in terms of how the contract is performed. It's also important to note that the architect's powers under Clause 2 are largely discretionary. The clause provides for the architect in his absolute discretion to issue further instructions to the contractor. So there's no contractual obligation there. Clause 4, which is variations arising from legislative enactments, is obviously of central importance to COVID-19. Clause 4 provides that where the cost of performance of the contract has increased due to legislative enactment or the exercise by the government of powers vested in it, that increased cost will be payable as part of the contract sum to the contractor. Clause 4 gives rise to a number of considerations in this context. Firstly, it's not entirely clear what costs are referred to, or in the context of COVID-19, the relevant period for the legislative enactment. But I think of a more fundamental concern, and perhaps something that often gets overlooked, is Clause 4 is perhaps the only example of a provision in the RIAI form contract where an employer or developer may be liable for additional costs without having failed to comply with any of its own obligations under the contract. Typically under the RIAI form of contract, compensation events are only provided for where there's been a failure on the part of the architect or someone instructed by the architect. Clause 30 deals with delay and extension of time. Almost all building contracts that are in receipt of bank funding will provide for a completion date. However, unlike the facilities agreement, which provides for essentially a fixed date by which the works must be completed, most building contracts, and the RIAI is no different, contain a number of extension events which on their occurring have the effect of entitling the contractor to what's called a fair and reasonable extension of time for the completion of the works. The period of time is to be determined by the architect, and where an extension of time is granted, there is a corresponding release from liquidated damages for that period on the part of the contractor. So again, it's important to bear in mind that there is going to be a difference or a gap between the level of certainty that a developer is providing to a funder under the development undertakings and the level of certainty in terms of program and completion dates that are likely to be provided for under your main construction contract. In terms of, I suppose, conclusions that I would draw from these points, the first is it can be difficult for developers to ensure the complete pass-through of program and cost risk to contractors. With regard to mitigation, I personally don't think we're going to move to a position where facility agreements provide for movable completion dates. I think just given the nature and the risk profile of debt financing, that's probably not going to happen in my view. I think what may be more likely is one of two things. Firstly, there perhaps will be increased float periods built into construction programs, perhaps both under the main works contract, but certainly under facility agreements. And secondly, I think you're going to see an increased amount of informal cooperation between funders and developers. And I suppose our experience to date, just to match what Karol said, is that there has been a very collaborative approach adopted, certainly in the cases that we have seen. In terms of cost certainty, it's likely that a number of contracts are going to see claims over the coming weeks. So one of the results from that may be increased examination of contingency in budgets for development finance projects, particularly in cases where there may not be sufficient guarantee in place for completion. Early engagement between lenders and developers. Karol touched on this point earlier, but it really is crucial. Given the uncertain nature of the current restrictions and the lack of clarity on where things are going to move to in the coming weeks, early engagement is key, and particularly in the context of the collaborative approach we are seeing so far. And then finally, I would say it's always important to be aware of the obligations in your loan facility agreement. Development undertakings are typically in place for the length of the construction period, and not just conditions that need to be satisfied on the date of signing or on the date of drawdown. So it really is important for borrowers and developers to be fully aware of the obligations that they've signed up to in the loan facility agreement and how they may be affected by COVID-19. The CP list, again, just to reiterate, this particular point is obviously of more relevance for revolving credit facilities where there are numerous drawdowns, but it's always worth reviewing the precise obligations that are attached to a drawdown and where issues may arise, to flag those early with the funder to see what approaches can be agreed. And with that, I'll pass it back to Jamie. I'm very happy to take any questions anyone might have.
Karol, Paul, thanks very much. Very interesting, and a lot there to take away, be you on the lending side or the borrowing side. I think the thing which is clearest from everyone's perspective is to ensure you are familiar both with your obligations in an existing facility or about to enter into one, to just familiarize yourself with everything that's in there. As you'd expect, there's been quite a lot of questions coming in. Some of them are quite common to other ones, so just to hit some of those common ones on the head for those of you who have joined the previous ones. No, Jamie will not be answering any questions. That's my prerogative as moderator, thankfully. I'm happy to see the lads squirm their way through the next 15 minutes. No, I'm not applying for a job in prime time. No, this is not my only shirt, but the others are all blue. Yes, no, I'm not wearing makeup, but I am using the very handy Zoom function that's there. And finally, no, we are all not lucky enough to have our homes decorated by the Stepford wives. So other than those questions, we do have some very detailed questions. In fairness to the guys, we're not going to be giving legal advice on this one. So if we can give you a steer, that'd be great. And please do pick up the phone to the guys afterwards. First one, thanks for yourself, Karol. What kind of amendments, if any, are you seeing in loans to the hotel sector?
I suppose, you know, again, would be done on a case-by-case basis, but I'd say the most obvious ones would be some more, possibly, you know, pushing out the delivery of management accounts, dates, and financial statements, like. Again, it would be done on a case-by-case basis, though, for each of them. What we would anticipate is that the heavier amendments will probably be towards Q3 and Q4 of the year, once people have a better line of sight maybe on how the health crisis is evolving. But from what we've seen at the moment, and speaking to clients, waivers of sort of certain breaches already, technical breaches, have been kind of fairly readily available from lenders. and they're certainly open to moratorias on principal repayments.
And then I suppose in terms of new facilities, Karol, are you seeing any COVID-19 specific CPs introduced? Or would you recommend that there will be, I suppose?
I have seen them. In terms of new facilities, I don't know how much they really add, particularly in development finance and investment property finance, when you have a signing, completion, and drawdown usually on the same day. So I think adding them there, doesn't add a huge amount other than a little bit more uncertainty, maybe to drawdown. As a CP to, as Paul was touching on, revolving credit facilities, which are quite common for the costs of funding the costs of the developments. They may be more relevant there, but again, the wording of them would need to be carefully crafted. For example, if the CP related to shutdown of sites, which happen at the moment, obviously happening at the moment, the borrower here might be coming to the lender for a drawdown to pay for work that was completed in the previous month. The work has been completed, and the CP may act as a draw stop to that. So I would be, you need to look at the wording carefully, and it's quite easy to, I think, take a defensive position from the lender's side to add in a CP as a kind of a knee-jerk reaction. So they would need to be carefully crafted.
Is that the same with cure rights for new?
No, well, in terms of cure rights, lenders, my experience, I won't speak for anyone, but they tend to be quite open to cure rights being introduced, certainly at the start of transactions. Given that it kind of works in everyone's favor, the more money comes in if it is a financial covenant breach. So whether cure rights are introduced retrospectively now by amendment into facility agreements, as again maybe later in the year, that kind of remains to be seen. On the kind of other side of that, the sponsor or the borrower will need to be in a cash position to avail of cure rights as well. So
okay, thanks, Paul. You touched on it there obviously in your talk, and we have one or two questions in relation to it. For contracts signed after the COVID-19 restrictions came into effect, will contractors be entitled to additional payments for changes in law?
Obviously, the terms of the specific contract will determine that. But if we were dealing with a standard RIAI form of contract, Clause 4 only provides for relief in respect of legislative enactments that were entered into after what's called the designated date. The designated date is typically 10 days before you have tender submission. So as a general answer, I would say no, that the compensation event in Clause 4 is limited to legislation that is effectively comes into place after a tender, after contract price has been agreed.
And sticking on that in terms of extensions of time and claims provisions, contractually, how will they be affected, or will they be affected where the borrower and contractor are related entities?
Okay, again, it'll depend on the specific building contract, and it will also actually depend on the status of the contractor entity under the loan agreement, whether there's any provisions in there. As a general statement, though, what I would say is that where you've related entities as borrower and contractor, a funder will typically expect the building contract still to be reflective of an arm's length transaction. So you'll still expect to see that relatively detailed schedule of amendments to an RIAI form of building contract. So it shouldn't make any difference. And actually, one other point I'd make, Jamie, is when you see related entities, particularly in the context of residential developments, sometimes you'll find that you have a development management agreement in place, and there may not actually be an RIAI form of building contract. There is no industry standard form of development agreement. They're all more or less bespoke. So in that context, it would really depend on the transaction.
And Paul, I suppose in terms of additional time, how is that determined? Is it determined by reference to the length of the shutdown, or who determines it?
It's determined by the architect, and the wording is a fair and reasonable extension. That's an interesting point, Jamie, as to whether it would simply relate to the period during which the site was actually closed, or whether the site closure resulted in further delays. That would be dependent on kind of a case-by-case basis on the claim submitted by the architect, by the contractor, the architect's view of it. And key there as well will be what steps has a contractor taken to mitigate any delay that isn't directly attributable to the site closure.
Okay, thanks. I think this one here is for yourself, Karol. Yeah, you touched on repeating representations. So for borrowers who are not currently in breach of their agreements, but anticipate because of the obligation to give repeating representations they might be in the short term, what advice would you have for them in the generic?
Again, I suppose depending on the reps, what I would say probably comes back to the point myself and Paul emphasised in terms of keeping communication open with your lender, because I suppose the more information you can provide the lender, I suppose the better the outcome probably be for both parties. What I would say is that, for example, material adverse effect is probably something all borrowers are going to have to analyse in terms of repeating reps as well. So any particular borrower, they won't be alone in that potential breach, misrep. And as I said before as well, we've seen lenders adopting very reasonable stance in terms of waivers as well for maybe kind of technical breaches.
I suppose, Karol, on that, like as well, and I appreciate you did say earlier on that we are fairly early into this, and maybe Q3, Q4 might be when we start seeing things actually happening. But have you seen any financial covenant level being amended or other financial covenants being introduced, for example, debt yields?
In short, not really. I haven't seen any financial covenants being amended yet, and I think it's probably a kind of holding pattern by maybe lenders at the moment, because it's quite hard to see in the short term where we'll be, even in sort of 2 to 3 months. So I think, again, that might be, as you rightly said, maybe further in the year when they just covenant levels, and also maybe when financial advisors get more involved with borrowers in terms of presenting, I suppose, ideas or proposals to lenders.
I think, in fairness, it's interesting when you see the questions which are coming in. I think certainly your Q3 and Q4 might be busy. And a similar phrased question or framed question again. Have you seen, or is it prudent to ask for interest pauses for the period of the downtime?
Again, it's a conversation that depends very much on the facts. What I suppose borrowers do need to keep in mind, particularly with domestic banks, are their own internal mechanics as well with their credit approval, and also internal audit requirements. And then on sort of a macro level, you have sort of EBA guidelines and ECB guidelines on forbearance and MPEs. So I think, like anything in life, if you don't ask for it, you don't get it. So speaking to your relationship manager in respect of your particular facility, yeah, there's no harm in that.
Paul, we might just take 2 or 3 more questions, just conscious of time. Paul, any practical steps developers might be taking to minimize delay to the completion of their developments caused by COVID-19?
Yes, of course. One example that we're seeing a lot of actually is in relation to design development, and to the extent it's possible to advance that during this period of shutdown. The regulations provide for the closure of construction sites. They obviously don't prevent people from working away in their offices on things like design development, which is obviously a key part and an ongoing part of most construction contracts. So we're seeing that being emphasized, particularly in correspondence between contract administrators and contractors. things like purchasing of long lead items as well is something that we're seeing regularly raised as points to note with contractors, with a view to minimising, where possible, any future delays.
And a very specific question, but maybe we might answer it in the generic. Like, in terms of who decides how much additional payments someone is entitled to, like who makes that decision, and have you come across or considered additional sums that might be incurred to take into account the fact that longer working hours might be needed to comply with working practices?
All right, to take the first point, the additional amount, if any, to be paid is determined in the first instance by the architect under the contract as the contract administrator. Separately, that would constitute, in all likelihood, a payment dispute under the contract, and as a payment dispute, the parties would be entitled to refer the matter to adjudication in accordance with the Construction Contracts Act. It will be for the contractor to establish, firstly, an entitlement to payment under Clause 4, and secondly, to satisfy the architect, the adjudicator, or whoever else may ultimately determine the dispute, whether it's court or arbitration, that the amounts being claimed are payable and, you know, are vouched in the normal way as part of any claim. I think the second part of the question, Jamie, was in relation to operating hours on site, was it?
Correct, exactly. Will contractors be incurring additional costs because they are obliged to have longer working hours?
I would say that actually will depend. I know what this is in relation presumably to the recommendation of the RIAI around reopening of construction sites, and one of the recommendations they made was that working hours on site would be extended to 16 hours, and you would effectively have 2 different shifts of workers on site during the day, with a period in between for cleaning and disinfecting of the site. Obviously, that would raise issues under most planning permissions, which have restrictions on the numbers of hours that people can be working on site. In terms of whether the contractor would be entitled to additional payment for that, Jamie, it would depend entirely on the provisions of the contract and the nature in which the extended hours were implemented under the contract. So there isn't a one-size-fits-all answer for that particular question. Okay, thanks. I think we'll take one more question, Karol. I think it's for yourself. And it's actually, I suppose it's very similar to questions which came up on the residential webinar and on the landlord and tenant and commercial leases webinar, in terms of formalising any variations, be they rent abatements, rent suspensions. But in your area, how formalised do you think any variations should be? For example, extensions to repayment dates. Should they be documented? I suppose the question here is bearing in mind the cost of formalising it would be put upon the borrower. But that aside, presumably it's prudent to formalise any variations.
Yeah. Just kind of come back to, in terms of waivers, banks can tend to do that internally and themselves, their own in-house counsel, and that's perfectly appropriate. In terms of more complex amendments, yes, it would need to be done by amendment agreement typically. If there are, I suppose, only 1 or 2 amendments, the amendment agreement is more appropriate than, say, an amend and restate. But I suppose back to our point earlier, later in the years when we anticipate documents being amended to that extent and sort of heavier lawyer involvement, which at present actually been quite light in terms of amendments.
Okay, thanks very much. We're just inside the 45 minutes, which I promised our events team we would keep to, so we will wrap up there. Guys, thanks very much. To all of you who tuned in, thank you as well. Our events team will shortly be circulating both links to the slides to answer one of the other questions we didn't get to, and to this webinar. They'll also be circulating a survey, so please do take the time to fill out that survey and give us any feedback you may have, including any future topics that you might like the teams and Mason and Curran to cover. You will have seen, or you will see rather, a link there to our COVID-19 page on our website, where there are also webinars dealing with employment, pensions, commercial contracts and insurance, in addition to all of those that we've dealt with so far on this Built Environment series. So for now, thank you very much, everybody.